Welcome to Third Fridays, the monthly legal talk show from Lois LLC featuring attorney Christian Seeson. This is the original forum in which real attorneys discuss workers' compensation issues, share their opinions, and engage in colorful conversations. This show showcases diverse perspectives of attorneys handling workers' comp cases, including case law trends, practical litigation strategies, and hot topics. Here's your host, Christian Seeson.
Happy New Year, everybody. The Third Fridays podcast is back. It's 2025, and we have some big news that you may have already seen on LinkedIn. You're going to see more about it on LinkedIn, but our firm is buzzing about 6 new partners at the firm. It's a really, really great time to just share the achievements of these people with the whole firm and with all of you now. I have 3 of them here with me today. So just from left to right, Meisha, Addison, Connor, welcome back to the show as first-time partners on the show.
Yeah.
Thank you.
Glad to be here.
I didn't really say your last names, but people probably know you like on a first name, like Madonna-style basis with the world, right?
Like that.
I'd like to think so.
Yeah, so like, we don't Meisha, Powell, Addison, O'Donnell, Connor, Wetherington. Congratulations on making partner effective this month. That was announced at our holiday party last month. And as we kicked off the new year, because we don't do anything slow, we wanted to establish the idea of good foundations in our firm-wide all-hands meeting earlier this week. And as we're sitting there, I started to think about, aside from the foundations in a good case, right, which is what, the purpose of the discussions really were, I thought it would be a good idea to talk about like good foundations everywhere, right? I mean, that applies to really anything that people are doing. People have all these like New Year's resolutions that they need to accomplish. Everybody has all these goals. And so what are the foundations of a good client? What are the foundations of a good teammate, right? We've had occasion to work with each other. We've had occasion to work with other attorneys, paralegals, law clerks. What stands out to you guys? Anybody want to like just kick us off in terms of, what about a particular type of teammate really helps everything that you do?
Well, this is Meisha. Hello, everyone. Happy New Year. I'll kick us off. So
is it just to riff a little bit, right? Like, when is it too late to say Happy New Year? Is it, I mean, listeners are hearing us for the first time, right? So it makes sense. But I'm just like curious, like when do people stop saying Happy New Year?
Well, if I've seen you already for the year, I should not say it again. I should say it initially and then that's it.
Okay, that's a good rule.
I think when the clerk doesn't say Happy New Year back to you, that's when you stop saying
right, when they're answering the phone and
Happy New Year.
Yeah, probably by February 1st, you probably no more.
February 1st is kind of late, I think. I feel like late January if you're saying it.
Groundhog Day.
Yeah.
Anyway, sorry, Meisha, go ahead.
Oh, it's okay. So, I mean, it's interesting when, a new file comes into the office. One of the things that I think makes for good foundation is to get excited about the case.
Oh, interesting. Yeah.
Yes. If the case is an interesting one, my main focus is on construction claims. But if right away, if that's an interesting case, like, my paralegal, the assistants we're all hands on deck, right? We're trying to figure out, correct. We're trying to figure out what do we need? What do we need to get from the client? We already know that we're on this expedited calendar. So we just start chipping away at, the facts, start figuring out what we need to know and what we don't know. And we go from there.
So how do you, let's touch on that excitement. You guys, when you guys see a case for the first time, whether it's, day 1 or day 30 or day 300, what do you guys get excited about, right? Meisha talked about when you guys get excited, you really start, you get that momentum, you start chipping away. So what are the things that you see that make you excited?
I think it just depends really on the nature of the case. Like sometimes if you're going through a case and you're just sifting through medicals, maybe there's like one new nugget in a medical report that changes the way I'm going to want to litigate it or attack the claimant or a doctor. It's something like that. And then I'm usually right on the phone to my paralegal, Crystal Karamanis, and I'm chomping at the bit to discuss it. And she's like, okay. But yeah, it depends. Or maybe you get an updated ISO report and there's like an undisclosed accident or something that wasn't there before. And it's like, oh, and then gets my gears turning, and I'm like a shark in the water smelling some blood.
And, Addison, you have a lot of experience like that because, when you write practice pointers for the firm, or when you're talking to somebody to get into their headspace when, you're writing an appeal, or really, anything that anybody does, right? It requires the conversation, right? So Connor is saying, I get this piece of information, this little nugget, and I want to tell someone about it, right? Like, do you think it's more exciting to tell someone about the nugget or to hear the nugget from someone else?
I mean, I've both been the recipient and giver of the nugget.
Yes.
I don't even know how that sounds like.
You know me.
Giver and receiver of nuggets.
The prospector of facts.
That's right. I've been in Christian's office jumping up and down about legal theories. I've been screaming, across the firm so that Meisha, whose office is across the building, can hear me. I knock on the wall for Connor, who's next door to me. Really, when it comes to excitement on a case, I am most interested in the gray areas. So much of workers' compensation, appears to be binary. It's either this, or it's, it either is or it isn't. And that's not necessarily the case. We can use ambiguities to our clients' benefit. We can use our ambiguities in the regulations, right? Especially in the pre-hearing conference, right? The regulations in the pre-hearing conference, even though they appear to be succinct, they appear to be concise and direct, they're quite ambiguous, and we can really latch onto it. And so when someone latches onto an ambiguity and changes it or wields it, moves it towards our client's interests, that's what gets me going.
Yeah. So like the things that are not black and white, not set in stone, that allow real lawyering to take place, right? But if as someone who does give and receive the nugget, right, which we all do, right, every single day, like you see something and there's a chance that someone else doesn't know the nugget, right? That is the most beautiful thing in a case, right? Because if you find it, right, it's yours, right? And then you share it, and then it becomes ours. And it's this crazy little train that starts to pick up steam, right? So Meisha, when you're talking to your paralegal and you're getting excited, right, you find the thing and you say, okay, I need this from the client. Now, obviously, anybody, whether it's internal, external, you want them to be responsive, you want them to help you, right? Like with all the types of construction clients that you have, what are the traits that you see in them that say like, oh, you're really my ride or die, right? We're gonna get this case, win or lose. We're gonna feel good about this partnership, this relationship.
Right. So it's so important, right, with the clients, for them to be on the same page with you. Yeah. Right. The lawyers, we come up with like a theory of the case, right? We want to, be successful, and this is how we think we're going to win. So for my clients and a lot of the cases that I, that I deal with, they're like high exposure cases. I mean, these are construction workers. Their AWW is significantly high. There's usually a third party action pending. So then there's money over there in that pot. So I think with my clients, when we need something because we're trying to prove a certain fact, they're typically really good at getting it for us because they know without it, it could make or break the case. So collaborating with the client, my paralegal, other attorneys in the building. I mean, one thing I love about Lois Law Firm is that the collaboration is celebrated here. So it's actually something that we do on purpose. Like we're told to do it. Like we talk to each other. We talk to each other in the kitchen, or I run out to Addison's office if I have like something interesting going on in a case. And I love the fact that that's celebrated. I think it makes a huge difference in like, actually servicing our clients.
Yeah, I think almost to the extent that, you build relationships with the people that you see every day, and it finds its way into your vernacular outside of business hours almost. Like, and not, to say that it overwhelms or consumes you, but like it becomes almost just part of who you are, right? When if I see you guys randomly on a Saturday at like the grocery store, I'm probably going to say something about workers' compensation. I don't think I could end that conversation without saying something. It's just who I've become at that point, like good or bad, right? Like,
Just talk about eggs like everybody else.
right. Like this might just be a referendum on my own personality.
I'd be like, Christian, not today.
Yeah, right.
Saturday.
Right. That's true. I get it. So, okay. So yeah, you have the client and you say, they're on the same page, right? And almost looking at the way you're describing that, I know that as attorneys, we propose these action plans all the time, every day, right? We don't have 100% hit rates, right? We could provide what we believe is a stellar action plan every single time, but sometimes also the best client is the one that feels comfortable telling us no, right? So, saying like, okay, you know what? Like, I don't want to do this because of XYZ. I think ABC is a better route. And for me, when I look at a teammate who proposes that action plan, receives the no, and is still moving forward, still very positive, that means that that teammate is really in it, right? They're not out just to get like the high fives, right? They find the celebration in the process, right? So like, can you guys talk about a time where maybe you've proposed an action plan and you've maybe received a no and you felt like, okay, like we'll do it that way and do it to the best of your ability?
Offhand, no. But
there you go.
I know there have been instances where I may have thought I found like a great nugget or something and kind of went all out of like being super aggressive. We got to do the X, Y, and Z. Maybe it's fraud, suspend, unrelated wage loss, something. And then the client's like, well, I don't really know. I don't want to, be that aggressive. Maybe it's a good employee. We don't want to scare them off. Maybe they're unrepresented and it's like they don't want to engage in a ton of litigation to where maybe an attorney comes on board and then now you're really having to fight it. So that happens. Of course, at least in my space with retail clients, sometimes it's a simple slip and fall and they go back to work. And it's not something that's overly litigated, such as Meisha's construction claims. But sometimes you got to know when to pull back a little bit. And that's part of knowing your clients, right? You talking about foundations. Every foundation is built on trust. And over the course of, the past several years of handling these particular clients in this space, we've learned to work with each other, trust each other, just client and counsel, and it shows.
And, in Addison, you have plenty of opportunities where, you're drafting an appellate brief and you speak to the trial attorney almost to get their vision, right, of how they were at the lower court. And like just the same as, a client, you're not going to have a 100% hit rate in terms of the agreements that you have with the trial attorney. What's that like? Like, how does that, really formulate what comes out of those conversations when, it might not be with me because I think I agree with almost everything you say.
It's because I'm insane.
Right.
Insane in the membrane.
So, those happen, right? I'm actually there probably have been times where we've disagreed, right? But like, how does that play out where you come out of that conversation feeling I now have a better place to do my part in this case?
Yeah, I mean, there's a couple of things. The first is dovetailing what Connor said. Trust goes both ways. Trust also is when you receive a no, you push back and say, well, why? Right? No, that's not a good idea. Well, wait, why isn't that a good idea? And vice versa. There have been plenty of times where I've come up with a theory or a strategy because where I sit, the perspective is different. And look, law is a team sport, right? So not one lawyer is his or her own island. And so compromise is really the art of the possible when it comes to litigation. So when I speak with a trial attorney, for example, who comes forth with a theory of the case, mostly it's fact-based. It's here's the evidence that I have. Here were my arguments to the judge. This is what the judge found to be credible or incredible. And where I sit is, yes, but there were legal errors at this phase, and this phase, because legal errors are reversible. Factual errors are really, really tough. In fact, nearly impossible. And that's part of the nature of our appellate system. But when it comes to writing, when it comes to drafting a theory of the case, I tell my clerks this here. I say this in the writers' workshops. Content dictates form, right? What you want to write will influence how you want to write it, whether that's an email, a letter, a memo, a brief, right? If you want to write an appellate brief on, say, whether an occupational disease was proven, you're probably going to lose on it, because if the judge found and the board panel found that it was proven, well, that's a factual question. But if you want to write an appellate brief on whether an occupational disease, as defined by the law, was applied properly, notice the little nuance there. It's a little bit of a splitting hairs here, but it has to do with, the distinctive feature of the employment. Was that indicated on any of the medical records, or was that just, taken out of thin air? Was that assumed? Was that inferred or implied? So at the end of the day, there, some of the most rigorous litigation happens within these four walls, because I might say, Connor, that fraud argument's, a little dopey. but then Connor comes through and comes in with the copy of the notice of decision, slams it on my desk and says, there you go, buddy.
60% of the time it works every time.
That's true.
The ideas that you kind of put out there, there's so much that, first of all, who is not just grabbing into that law as a team sport? That's got to be on a t-shirt, right?
You said there's a vernacular that we take from the firm. I don't know anything about hockey or football or baseball or basketball, but I use them as metaphors all the time. Thanks to you, probably. But it's true. Law is a team sport.
Law is a team sport. And then you mentioned something about the idea of reversible error as your categorical way to find success, right? Versus factual error. And, Meisha, as an experienced trial attorney, right, you're dealing with that, but also the factual stuff, right? Because the factual stuff isn't yet determined until the trial judge makes a decision, right? So, Connor, same thing, right? Like when you guys are preparing for trial and the case turns on that one or two facts, right? Because if it's this way, it's for me. If it's that way, it's for you. What does that feel like when it first starts to occur at trial? Because you don't know when the fact is actually going to turn at the trial, right? You might have questions prepared. You might have the idea of I'm going to introduce this exhibit now, or I'm going to refer to this medical report at the end of the summation or the beginning of the summation. But there's always that light bulb moment where you're like that aha, oh, it's happening right now. What do you guys feel like when that's happening?
First, the preparation when you're going into a trial is so important. So when you're preparing for the trial and you're figuring out the facts and even your questions, I hate to make an OJ reference, but if that glove doesn't fit, you better know if that glove is going to fit.
All right.
Right. So
there could have been so many worse things you said.
I know. No.
I was actually
I'm just talking about the glove. So
John, breathe easy when you're listening to this. We're keeping all of that because
people forget OJ, great football player.
There we go. So with me, when I'm preparing for trial and, you have your questions prepared, you should know the answer or anticipate the answer from the claimant, or you should anticipate how they're going to try to refute that. So you're kind of working with two theories at the same time. So, and I think the preparation helps with that, right? So in some instances, there's questions that you're not going to ask because you may not know the answer to it, or you may know that the answer is not going to, go in favor of what you're trying to prove for the case. But there's been times where, you're asking the questions and you do get that aha moment where you're like, I didn't even have that.
Right.
And then you just start building on it. And then you just need to pivot. And then maybe that's the one thing that now you have to kind of just drum in, because that could be the one thing that makes the case go a different way.
Right.
I think Meisha just said the key word there, pivot. You have to know how to pivot, because you can, at this point, if you're a more of experienced trial attorney such as Meisha or myself, we've done enough of these trials that going in, okay, we know that the claimant's going to answer it this way or that way. You can already predict. It's almost like a sixth sense in a way. But I think knowing how to pivot is key. If you can tell that it's going against you, maybe you just take a brief pause in questionings, or like say, sorry, Judge, let me look through my notes. Try to regroup and gather yourself. But if it's going, maybe bad, or a fact or a witness maybe said something they didn't tell you, and it's like, oh no, how do I get out of this? Knowing how to pivot is probably one of the most important skills of being a trial attorney. And then for me, if something flips more in my favor, let's say I got a stinker of a claim, and then the claimant starts talking and keeps going, I'm like, ooh, then like the gears are turning.
The shark is in the water.
I'm coming to feed. And for me, it's if you're sitting in a trial with me, it's pretty easy to tell when I see that light bulb and it's going in my direction, because then I start to smirk and I'm like, ooh, I know I got him. I know. Well, thank goodness the video recording is not recorded, just the audio, because I'll make a face.
Meisha won't make a face.
Meisha's very stoic. I'm a little more animated when it comes maybe to trials, throwing hands up in the air, pointing. Maybe I'll slam the desk.
That's great, though. That's great.
Preparation, right? Like preparation allows the pivot, right? And also you have to almost make a mistake to know how damaging it can be. Like, if you don't fall on your face, then the opportunity to see it down the road becomes possible, right? Like I always like to say that no one ever got good at anything without being bad at it first, right? And so one of the things that I love about this place is that there are so many different opportunities to try out new things, to shop talk, to workshop, to test things out, right? All of our programs, all of our discussions, all of our events, you're really putting yourself in a situation, if you really want to have that for yourself, to mess up before the real thing, right? It's like a testament to how far we become. I mean, I remember my first day doing workers' compensation and hearing that I had a trial in a week on a summation brief that I had to do the first day, right? And it was, I didn't know, apples from oranges, right? And to the point where we now have the capacity to help an inexperienced attorney to make those pivots. I mean, I think we're seeing that really evolve because, you guys talk about yourselves being experienced attorneys, but years ago you were not one, right? And now that light bulb moment, or that aha moment, that would have passed you by, right? It probably did at some point, right? There's things that happen that you can't see if you don't prepare. And I think that's, the one equalizer, right? You can walk into a trial and your adversary could be, I don't know, the person who wrote the workers' compensation law. Obviously they're not alive at this point, but if they were, if you prepped your file, you're going to be okay, right? The world's not going to end.
If Governor Al Smith walked into the Workers' Compensation Board, I would faint. Big fan.
Right. Addison probably would just like, it was like, okay, just for you, I won't note exception.
1930s. Yeah.
I mean, you're a man of the 1930s, so I think that
Still using kerosene lamps and fountain pens. I'm kidding.
so
Not really.
yeah, I mean, like I think it's a real big distinction, but the whole preparation aspect still requires all of those things, right? You need good teammates and you need good clients, right? You need a good client, and sometimes you might not have one, and sometimes you might not have both. What do you guys do in that scenario?
Well, I think as far as a good teammate, we all have great teammates and we all have great clients. One of the challenges that may be is maybe a client is not as responsive as you need. Well, that shouldn't deter you from your goal or your mission. You still got to go out there and, at least develop the best record you can. Maybe it is kind of throw in the spaghetti at the wall and seeing what sticks when you get to trial. And then if it still doesn't work, you're preserving the record so Addison can go correct any factual or legal errors that may have been made on the record by the
Just want
judge.
one spaghetto to stick.
That's right.
Yeah, you just need one. It's just one little loose thread, then you can pull it and everything unravels because you never know. I don't like to go into trials or hearings or even depositions, asking questions that I don't know the answer to already. But sometimes if I know I'm up against the wall and I'm like, I got to do something, got to pull the rabbit out of the hat, maybe I'll just throw a little question out there that I don't know and see what happens. Just let them get to talking, because sometimes claimants, once you got them feeling good and you're on their side kind of in a weird way, they start to loosen up. And then they start to divulge some information that maybe they didn't need to, and then that's when you got them.
I have to, Connor, I feel like I want to dovetail from everything that you're saying. I'm piggybacking, new metaphor, piggybacking on what Connor said. What is order to the spider is chaos to the fly, right?
Hold on.
Now, that being said,
golly.
all right, fine, I'll do a sports translation to all the sports people.
What is chaos to the spider?
Now, what is order to the spider is chaos to the fly.
Chaos to the fly.
Well, let's do the sports translation here. The best defense is a good offense. So Connor is being pushed against the wall and he wants to pull the rabbit out of the hat. In reality, he's trying to make order out of this situation, and he's trying to take control. The claimant bears the burden of proof every step of the way. That's very difficult, right? The claimant is saying, I am suing you.
That way, but you're right.
But the way that, the way that it happens is the claimant is making allegations and must support these allegations with something. Either it's sworn testimony, either it's circumstantial corroborative documentary evidence, either it's medical evidence, deposition testimony, And so when we're getting pushed against the wall, we take the one thread and we try to make order, because soon enough, the claimant will get caught up in his or her own web.
Absolutely. I agree with that. And it's interesting when you get these cases sometimes where it's like, oh my goodness, like this is like a nothing burger. Usually those are the ones that are a big deal once you start pulling at those threads. I mean, one of the things that we have discussed in the past is like the C3. The C3 has such good information. And in fact, sometimes the things that are not included in the C3 is how the case turns, right? So, the claimants are supposed to fill this thing out, right? Most of it is 50% completed. I don't know the last time I've seen one that's 100% completed. But, there's certain ways that, we as carriers, we go in and, we may have to delay the case just so that we can, gather more information. And sometimes it's a C3. There's all these things missing. You ask the claimant, sir, have you had any prior accidents? Oh, yes, I had one, 2 years ago. Your C3 is blank. There's nothing there. Judge, we're done here. Like, failure to, whatever it is, right? The case should come off the calendar because Addison just stated it's the claimant's burden. So we just have to be able to pull at those strings until, something.
That's a very interesting point, because we have this pre-hearing conference, or even in an accepted claim, right, where, you might just be thinking as a claimant's attorney, this is the thing that we do to get the awards running on a continuing basis, or in a pre-hearing conference, they're telling their client, we're just going in there to get a trial date, right? And you're right. A C3 is so foundational. I mean, it's obvious to anybody who has worked a case that you need the C3, but I think knowing what a complete C3 looks like, right, makes you realize what an incomplete C3 really, how it prejudices an employer or a carrier. And so, we talk about, for instance, what the claimant has to prove, right? And, Addison, you're talking about all the steps that they have to do to support every tenet of compensability, right? Accident, notice, causal relationship, employer-employee relationship, coverage, like all that stuff that they have to show to say, I have a compensable claim. And most of the time, I mean, you're saying, Meisha, that I can't remember the last time I've seen a 100% completed C3. It sometimes makes me wonder that, because it's purposeful, right? It's purposeful that C3 is incomplete. And so that's like, you talk about getting excited about a case. Like when I see a C3 that's not perfect, it's like, yeah, let's go. Like where can I start playing? Right?
So, but you can only conclude that it's purposeful because of the aggregate amount of cases that you've seen with incomplete C3s.
Right,
So
right.
it's contextually, relevant as well. I dream of a perfectly completed C3. I dream of it. Was an object used? Yes. A forklift. Was notice given, orally written?
I think forklift is in the parentheses for was an object used on the C3. That's how
I
many
think so.
C3s.
E.g.
forklift.
Right.
That's how many C3s you've seen.
I know.
You're telling me that I have to ask you about eggs on Saturday in Super Bowl. You're having dreams about a C3.
That's right. That's right. Well, what you work with every day bleeds into your real life. So, I have to admit, I would, if I ran into Meisha or Connor in the grocery store on a Saturday, I would say, that grocery cart wheel is a little wonky. If you were getting our boss some eggs, I don't know. Doesn't seem like a deviation to me. But that's the nuances of our system.
Yeah, I think that the overwhelming opportunities you have, like in a volume industry like this, right? And just think about when you log on to eCase, right? Like, they actually have that identifier for like on the screen of how many documents are in the docket. Those are like 782 documents, right? And I think there's just some also level of there's like pride almost that it's like you can log in there and, right? It's order to us once you know what's going on, right? Like anybody that hasn't worked on the file or really doesn't have a good process for attacking that file is going to be like 782 documents. How are you going to summarize all those in a 15-minute first time on hearing? Like, what are you going to do, right? And
For the left thumb.
right. And I think that there is some level of pride, right? I saw it in your guys' faces when, you're announced as next partners, right? Like what gets you to that point where you can feel that level of pride? And not only that, like other people can see it, right? People, like, it starts to spread. What is there anything that, people can take away from that so they can get to where you guys are now?
I mean, I think for anyone that's interacted with me or know my personality, 80% of the time I'm like have a smile on my face unless I'm really like into my cases and I'm litigating. But I mean, I get excited about this stuff.
Yeah.
I don't know. I'm doing this construction litigation. I'm extremely excited about it. I'm not pretending to be excited about it. It actually excites me. And I think when I'm talking to other attorneys, colleagues, my poor paralegal, by now she probably thinks I'm nuts. Because every case I'm like, oh my gosh, look what happened here. This is where, and I'm really at that like level of excitement. But I think it helps her because then she's like, oh my gosh, my attorney's so excited about this case. Okay, I'm excited too. So it's almost like, I don't know, it's just the wheel that just turns in my head, and it just helps us to get through these cases.
Helps to have a paralegal that's the reigning mock trial champion, though, right?
That helps. That helps, Karen. Hi, Karen.
You gotta be a little crazy to do this in a weird way. You gotta be a little crazy because you're already at a disadvantage from go. As soon as that claim's filed, everything is stacked against you, and then now you have to push all of this back off you. And I think, as far as my paralegal, Krista, I mean, she matches my energy day in and day out, and that is huge for me.
She's pretending sometimes.
Sometimes, yes.
That's for the good of the group, though.
Good of the group.
Right? She is a good teammate because she sees how excited you are. And, she might be in the middle of a summation brief, but, she's taking that call. Like, I've seen it in real time.
Oh, yeah. It happens because, like I said, I find that little nugget and I got to go talk about it. I got to do it right now. But her matching my energy and, like, being there and letting me, or being my soundboard, really, for, like, bouncing off all these crazy ideas. And sometimes, like Addison said with trust, is saying no. Like, she goes, I don't think that's a good idea. I proved her wrong in one claim by submitting the video, but that's neither here nor there. And then the other part of having people see this energy, like I think we've talked about this on the show before, I am known to run out of my office after a great win, whether it's a disallowance or a fraud finding or whatever it may be. And people in the office have to stop and go, what the heck is this guy doing? But I want to show everyone that's right. The excitement and what it can do, and it's because we're always at the disadvantage, and getting that win, it should be meaningful, it should mean something. And even with the people that I manage, I like talking shop with them and looking at their cases and asking questions, because then I'll start to get in it and start looking through it and get excited, and they can see me get excited, and I think my excitement radiates to them, and I think that's key.
So, Meisha, you have to be excited. Connor says you have to be weird. Well,
no, I said crazy.
Crazy.
And I nodded. I said,
right. A little bit of crazy.
Isn't that funny that you interpreted crazy to mean weird?
Oh,
I love that.
I mean, I consider myself very weird for how crazy I am.
I see. So there is a synonymousness there.
I think I have a weird brain of how I go and I attack these cases and how I like look at things, but I got a screw loose. So
that's right.
We'll leave it at that.
I mean, I love when the Georgia Yip comes out of his office. Woohoo! I'm like, wow, here we go. I'm about to hear it. The original question, Christian, was how did you get to your seats? It was something around that. How did you get here? And I think, listening to Meisha and Connor, and of course yourself, the cream always rises to the top, right?
That is an Addison O'Donnell. I mean, you said so many of those little sayings, but I think you have said those words to me maybe 50 times.
Probably. The cream always rises to the top. And the meaning of that is a good thing can't go unnoticed for too long, right? So if Meisha wins one case, great. If Meisha wins 5 cases, wow. If Meisha wins 15 cases, okay, all right, she's going somewhere. 100 cases later, 200 cases later, 800 appeals later,
20,000 pages of labor market attachment proof later.
That's right. Eventually you can't unnotice someone who's good, proficient, excited, weird, crazy, right? Devoted to the work that we do. And I think that's certainly how I got here, but I think present company included, I think that's the explanation why we are here right now.
Yeah, I think that's kind of a great way to kind of close it up, right? You do enough good things, and it's impossible for it to go unnoticed forever, right? And obviously there comes with that, a lot of good instincts, a lot of good feedback, and sometimes constructive feedback. And you go along this journey and you reach something that, as not just attorneys or law students, I think of it almost as people who take the bar exam, right? If you're taking the bar exam and there's a small part of you that wants to actually be a lawyer at a private law firm, you are thinking about that potential to become partner at that law firm, right? And I can tell you guys that, that moment where Greg Lois said to me, it was actually at like a private chat that the two of us were having, that, okay, we're going to make you partner, and it's going to be on this date. This is how we're going to do it. I felt like everything that had led up to that point, good or bad, contributed to that outcome, right? Because, we learn from our mistakes, we celebrate our wins, and at our core, every lawyer just wants to see that come to fruition, right? You talk about foundations of a case. You want to see that trial disallowance. You want to see that appeal reversal of an incorrect establishment of the case, right? You want to see your teammates succeed. And I think if you are an inexperienced attorney or an experienced attorney, and you're listening to me right now, and you feel like your promises given to you are still left unfulfilled, I would just say, rewind and listen to this thing all over again, because getting interviewed by Greg Lois in 2013, changed my life. And it's a situation where I think everyone would want to be if they're ready for it. So I think we'll end there, right, guys? You guys want to add anything else? For Meisha Powell, for Addison O'Donnell, for Connor Wetherington, my name is Christian Cison. It's actually been a rare occurrence where everybody in the room is a partner. So to my fellow partners, and to our three partners that could not join us today, we should say something about them. Ian Haberstroh, Vandana Saunders, and Matt Shrieks. We congratulate you as well on all your achievements and joining the ranks. We look forward to the best 2025 for Lois Law Firm. So from everybody, my name is Christian Cison, reminding you to defend from day one.